Good morning and welcome to the fourth episode of Coffee with Casey. I'm Casey Hicks, a shareholder and the Chicago office managing attorney here at Weltman. I want to thank you for signing in to this session and for submitting your questions in advance during registration. I'm looking forward to discussing probate today. This morning, I'm drinking a cup of dark matter coffee as well as Laura. How about all of you out there? Feel free to send in what you're drinking this morning through the question feature on the control panel while we meet Laura. Laura, good morning, and thank you for joining me today. Would you mind telling everyone a little bit about yourself?
Sure. My name's Laura Alms. I was born and raised in a small town near DeKalb, Illinois. For those of you that aren't familiar, it's maybe about an hour and a half or so directly west of Chicago. Only 650 people in my town when I was growing up, but they have a stoplight there today, so it's booming. I went to the University of Illinois, go Illini, and the Northern Illinois University College of Law, which is in DeKalb, near where I grew up. I've been practicing law for 10 years now. I'm in my 5th year with Weltman, and my focus is on consumer collections, but quite a bit of my background was in probate and trust litigation. On a personal note, my hobbies include all kinds of crafting, and I love to travel. And if I can combine travel and crafting, as I'm doing right now, making Christmas ornaments for my family, then all the better.
Awesome. Thanks, Laura. Before we jump into the presentation today, I just want to go over a few ground rules. Please remember this is an interactive session, so please submit any questions that you have throughout the presentation through the question button on the control panel. Also, this webinar is being recorded. At the conclusion of today's session, a link to the recording will be sent to all attendees. Lastly, there will also be a short survey on your screen at the conclusion of today's event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. And if you have any ideas for future topics, please let us know. Okay, finally, before we get started, the necessary webinar legal notice. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided is not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. The presenters advise you to seek competent legal advice on these topics. This seminar or seminar material does not create any attorney-client relationship between you or the law firm of Weltman, Weinberg, and Reese. And with that, let's get started. Today, our key topics that we're going to be discussing are defining powers of attorney, or POAs for short, and guardianships, the uses, the pros and the cons of POAs and guardianships, and applying the best practices to avoid common pitfalls. So with that, Laura, I will turn it over to you.
Thanks, Casey. So kind of the inspiration for this topic is questions that come from a lot of our clients, banks, credit unions, trust companies that are confronted with people that may come into their institution to make decisions on behalf of another person. You know, they might say, oh, I'm the POA, I'm the guardian, I'm the executor, what have you. And a lot of those terms can be confusing. So we wanted to start by defining the two that we're going to focus on today, which are powers of attorneys and guardianships. And what these do are grant one person the legal authority to make decisions on behalf of another living person. So we're not talking about something like an executor for the estate of a deceased person. These are strictly powers that one person can hold on behalf of another living person. And specifically today, we're going to talk about between adults. So if you have a child, obviously the parent can make decisions on behalf of the child. But what happens if there's an adult that needs another person to make a decision on their behalf? So in terms of POAs and guardianships, who grants the authority? It depends. With powers of attorney, it can be voluntary, so you can pick who's going to act on your behalf, or it could be ordered by a court in the case of a guardianship. For example, if an adult is incompetent and they can't make decisions, a court would step in and order that. Both types of authority are, excuse me, created and governed by Illinois statute. And generally speaking, when you think about the types of decisions that you can make for yourself as an adult, they fall into two broad categories: health decisions and financial decisions. And so as we talk about powers of attorneys and guardianships, they're going to both fall into those categories. We're going to talk about POAs for health, POAs for finances, guardianships over health, and guardianships over finances. And
sorry,
we'll go to the next slide.
Yeah, sorry.
That's okay. I'm going to take the opportunity to take a sip of my coffee.
Exactly.
So we'll start with powers of attorney. What are they? It's important to note that a power of attorney is a document. So it's not going to be verbal authorization. It's a physical document that somebody would be in possession of that would demonstrate that they, as the agent, have the authority to make a decision on behalf of a principal. In Illinois, powers of attorney are standardized by the Illinois Power of Attorney Act. So the forms for both types of powers of attorney are set forth in the statute to make it very uniform and easy, especially if you are a financial institution that might be confronted with this quite a bit. It's very easy to pick out the statutory form. As you can see, it'll have a big bold title at the top: Illinois Statutory Short Form Power of Attorney for Property or Power of Attorney for Healthcare. The sample that we've got in front of us is a power of attorney for property.
Laura,
and you can
sorry, Laura, we did have a question come in.
Oh, sure.
The question is, can a power of attorney for health and property be combined into the same form?
Generally, no. In Illinois, they're always going to be separate forms. And this is really nice because the powers that they grant are really very different. And if you think about, your own life and the life of people that you love, the person that you want to make your financial decisions might not necessarily be the same person that you want to make your healthcare decisions. Let's say you've got one sister who happens to be an accountant, and that would be the perfect person for financial decisions, and maybe your brother's a nurse, and that would be a better person for healthcare. So it's really nice that they are kept separate, and the powers are really well defined by the statute. In terms of scope, a power of attorney is broad, but it can be limited by the language of the document. So one common misconception about powers of attorney is that they only come into play when the principal is incapacitated. And that's not the case. A power of attorney is valid from the moment that it's signed until the person dies. So you can exercise a broad range of authority on behalf of another at any point, not just when they're under some kind of incapacity or disability, but you can limit that by the language of the document. So if you want someone to only be able to make decisions if you're incapacitated, you can make that very clear in the document. Otherwise, the person has broad authority to act on your behalf, particularly with the financial power in all types of manners and transactions, unless you specifically limit it in the document.
And Laura, we had another question come in. The question is, how do you amend a power of attorney?
It can be freely amended at any point. You can amend the same document, or you can create a new amended power of attorney. So it's really nice because it gives you a lot of flexibility. You can also amend it in terms of the time frame that it's valid, the types of powers that you might want to grant. And you can also be flexible with it in that, like, let's say, for instance, if I want to sell my home, I might want Casey to handle that financial transaction for me, and I might give her a power of attorney that says that she's authorized just to handle that specific transaction, maybe just for December 2022, a specific period of time where she's only allowed to do specific things. With regard to whether or not the document is valid, in Illinois, again, it's set forth very clearly in the statute what needs to occur to make the power of attorney valid. It has to have a signature by the principal, it has to be signed by a witness, and it has to be notarized. And there's specific items that cannot, or specific people that cannot serve as the witness and notary, and that's to prevent any kind of fraud, undue influence, anything like that over the principal. So specifically, the agent or the successor agent can't be the witness or notary. An attending physician, mental health service provider, or any relative of those people. An owner of a healthcare facility, including parent entities. Parent, sibling, descendant of either the principal or the agent, or the spouse of any of those people. And that's just to prevent any kind of undue exercise of authority over the person, or power or coercion of any kind. And specifically, the owner or executive of a healthcare facility, including parent entities, could be important for our clients. We represent quite a few healthcare facilities. So you want to be careful if you are in that position, that if someone is in your facility and they need a power witnessed and notarized, that you find the appropriate people within the facility to do that. So it can't be an executive in the facility. And with the healthcare power of attorney, it's the same as the property, except there's no notary requirement.
And we do have another question, Laura. The question is the agent required to accept? And if so, how does the agent accept?
The agent is not required to accept. The agent can give a specimen signature, but that signature isn't required to accept the power. If you're the principal, it's a best practice to have that conversation with anyone that you want to act as your agent, to make sure that they know what you've designated them to do. Make sure that if you have any kind of questions about their authority, or they have questions about their authority, that it's very clear between the two of you how you want them to use that power. Some pros of the power of attorney is that it's voluntary. So the principal exercises full choice, authority, and control over the relationship. They can choose the person that they want to serve as their agent, someone that they trust, and that could change over time. They could amend it, and it's completely up to them. No one's making that decision on their behalf. It's private, it's not filed with the court, and it's very customizable. So as we kind of touched on before, you can limit the time and the scope, the type of authority that you want the person to have. And Casey, if you want to switch back to that slide number 11.
Sure.
It's spelled out at the bottom of page 1 and the top of page 2. It lists all different types of authority that you might want to give the person. And like we said, the power of attorney is very broad. So unless you strike out any of those powers that are delineated in the document, your agent has the power to do all those things. So as you see in the middle of page 2 there, You can say specifically things that you do and do not want the agent to do. So somebody might come to you with a power of attorney where that entire list is stricken out, and maybe on page 2, it's specifically said, you know, Casey has the authority to handle X real estate transaction on behalf of me for X period of time. So it's very flexible, which is definitely one of the pros of the power of attorney. Going back to that pro slide.
Okay, just to be clear for our audience out there, Laura, so if you do not want the power of attorney to have any of these powers in the paragraphs A through O, they should be stricken out. Is that right?
Yeah, that's exactly right. So if it's not stricken out, then the person retains all of those powers and then some. As you see, the last item delineated there is just kind of a catch-all. So if you want to give this power for very specific reasons, you should make it clear in the document.
Okay.
And the pros for the healthcare power, you've probably heard of a living will or advance directives. Those are documents that you can put in place as part of your estate plan that sets forth how you want to be treated in terms of life-saving measures and things like that. The power of attorney over healthcare takes all of those different piecemeal documents and combines them into one. So whoever your healthcare agent is can make all of those decisions about what type of healthcare you'll receive, but you can specify within the document how you want them to act. So they aren't necessarily making just their own best judgment at all times. You can say, you know, if I'm on a ventilator, I want that to be removed at a specific point in time. And the great thing about powers of attorney is that you can have this authority in place without incapacity. So you can have your power of attorney that's in place, and it doesn't have to be in case of an emergency. So if you don't have the power and something comes up, there could be all kinds of questions about who has the authority to act on your behalf. If you have the power in place and there's an emergency, then there's absolutely no question. That power is ready to go, and that person can step in and make financial and healthcare decisions in your absence. Cons is there's a high degree of trust required and there's no oversight. So we'll talk about guardianships in a few moments, and there'll be a clear contrast because the guardianships have a high degree of oversight by the court. Powers of attorney, as we said, they're not filed with the court, so it's totally private. Nobody's keeping track of you or your agent. And that person has that broad degree of authority. So they could be doing all kinds of things behind your back if you do not trust them. So it's important that they know exactly what's expected of them and what they can and cannot do.
And Laura, real quick, we did have a question come in. What if the agent refuses to act?
If the agent refuses to act, there is a portion of the power of attorney that allows you to appoint a successor agent. So if you have appointed a successor agent, that person could step in. If there's nobody that's named as the successor and the primary agent refuses to act, if you are not incapacitated, you can certainly execute a new power of attorney or choose a new agent. If you're incapacitated and that person refuses to act, then we come to a situation where we may need a court to step in, and that would be a guardianship scenario.
Okay.
So guardianship, what is it? Similar to the POA, it's one adult having the authority to make decisions on behalf of another. But in this case, this relationship is created by the court and not by the principal. It's created and governed by the Illinois Probate Act. Even though we're not talking about a decedent's estate, when it's a guardianship, we also refer to it as a guardianship estate governed by the Probate Act. It does require a petition to a probate court in the county where the ward or the putative ward resides. So the language here where we were talking about the principal before, now that person is referred to as a ward, because this is a situation where somebody is putatively under some kind of incapacity and can't make decisions for themselves. It requires an investigation by the court because as an adult, to have the ability to make your own decisions taken away from you is a huge deal. So the court wants to make sure that the person petitioning to have that power taken away from you and placed in the hands of another is acting in good faith and that you are actually under an incapacity. So generally the court will appoint a guardian ad litem, and that in Illinois is an attorney generally. That person would interview the petitioner, they would interview the ward, they would make sure that mental and physical health examinations are given to determine your mental and physical conditions and if you actually do need assistance in having a guardian appointed over you. And it could also require a bond depending on the circumstances, which is basically like an insurance policy to make sure that there's no malfeasance that occurs.
And Laura, is there any sort of time frame or time limit for the court to conduct this investigation?
Typically not. It happens very quickly because it's usually an urgent situation. And they can be drawn out for quite some time. Depending on the scenario, you can have emergency guardians appointed that then would be converted into a permanent guardianship after thorough investigation. And like we talked about with powers of attorney, there's two main types of guardianships, one over the person, which is the health, and then one over the estate, which is the money. Typically, the person that's petitioning is petitioning to appoint themselves as guardian, and that person would be appointed in both capacities, person and estate, but not always. And so the authority of the guardian has to be granted by the court. Once that investigation is done, then a valid guardian will have letters of office, just like you might be familiar with an estate. So if somebody came into your financial institution and said that they were the guardian, they should be able to show you letters of office that's signed by a judge and stamped by the court clerk. Guardianship cons is lack of control. So unlike the POA where you're deciding who acts on your behalf, this would be somebody else coming in to petition the court on your behalf, oftentimes on an emergency basis because a family member or a close friend has realized that something that often it doesn't seem like you have the ability to make your own decisions, or maybe there's been a terrible accident or something has occurred where you just can't make decisions on your own anymore. Oftentimes family dynamics could come into play as well because you're not the one that's choosing who gets appointed. A lot of times there could be infighting between children, siblings, people fighting over the control or who thinks that they have the person's best interest at heart. Another con is that there is a successful guardianship in place and that person can no longer act. It could be difficult to identify a successor to take their place. And sometimes if there's nobody to take the place and that guardianship is already pending with the court might have to step in and ask the state office or county office of guardianship to come in and take control of that guardianship estate. Best practices in avoiding pitfalls. If someone is in front of you claiming to be a POA or a guardian, you want to first take a good look at the document that you're being presented with. So for a POA, make sure that the document you're examining is fully executed by other required parties, that it's been witnessed for that property power, make sure that it's notarized. Guardianship, make sure that the letters of office are official, that they have a file stamp, and that they have the signature of the judge. Highest and best practice would be to make sure that there is a certified copy from the court. And for both POAs and guardianships, if the principal and the ward or the agent and the guardian visit you together, just be aware of signs of abuse or coercion, and make sure that the principal, or I'm sorry, the ward, you know, it doesn't show any signs of distress or it doesn't seem uncomfortable. Make sure that it's a situation that they want to be in. And sometimes that could involve maybe having a private moment with that person outside of the guardian or the agent's presence. So for both POAs and guardianships, you should confirm that the document that you have in front of you grants the type of authority for the decision that's being made. So for example, if somebody comes in to a bank and they want to withdraw funds from the bank and they present a POA for healthcare, that's not going to be good enough to make that withdrawal. You want to make sure that the POA is for property.
And for Laura, that will be on the heading of the POA, is that right? It'll say for property or for healthcare?
Yes, that's right. And also for the letters of office for guardianship, it should say right on the face of the document that it's for healthcare and for property. If it only specifies one or the other, then you just need to make sure that the type of decision that is being made is covered by that document. So if you're a healthcare facility and you have a POA for healthcare in place, but then all of a sudden you need to have a financial decision made on behalf of a person, it would be a best practice to have both POA for healthcare and for property, because those two don't have any crossover. And you could end up in a situation where maybe you need a bill paid and there's nobody to act on behalf of that individual. So it's a best practice to obtain all that type of documentation in advance and allow time for review. What if I'm deceived? So I've heard this question come up from clients because fraud is an unfortunate reality in our world today, and people could be trying to pull a fast one. The good news is that in Illinois, the statute for powers of attorney does provide protection and release for those who rely on a power of attorney in good faith. So ultimately, it would be the bad actor that is going to be on the hook, and not you as a person that's acted in good faith.
That is good to know. Well, with that, that concludes our webinar today. I hope you found today's presentation informative, and I'm happy to announce that we will be moving forward with episode 5. Special guest Stephanie Collier will be joining me. The date and the details for that will be sent out soon, so please stay tuned. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know if there's any future topics you would like to see discussed on this webinar series. Thank you again for attending, and enjoy the rest of your day.
Thank you. Thanks for the coffee, Casey.
Thank you.